I would like to warmly welcome everybody. And as the host of the panel, I would like to thank you very much for your presentations. It's a great honor to have you here. And thank you, Professor Sobczyk, for moderating my panel. And today I would like to say a few words about the relationship between the Court of Justice of the European Union and the Constitutional Court of Romania. And I would like to present this relationship via the network of tools used in the judicial dialogue between the two institutions. As you can see on my roadmap, first I will say a few words about judicial dialogue in general. Previous presentations have dealt with this topic. Then I would like to focus on the relationship between the Court of Justice of the EU and the Constitutional Court of Romania. And last but not least, I will list 4 different methods of the judicial dialogue, 4 different tools. So what is judicial dialogue? There is a consensus in legal literature that this whole concept serves as a basis for loyal cooperation between European institutions and the actors of the member states. And most importantly, it serves as a basis for loyal cooperation between the Court of Justice of the European Union and national constitutional courts. In the Romanian legal literature, one can find 2 approaches trying to define judicial dialogue. Descriptively, some scholars describe or determine this concept as something based on the interaction between different levels of legal systems and jurisdictions and actors and institutions and so on. Whilst normatively, some consider that this whole judicial dialogue concept is based on a need for collaboration. And according to Iulia Motok, a well-known Romanian scholar who is currently serving as the Justice of the International Criminal Court, one can differentiate between 3 main contacts in the relationship between the Court of Justice and national constitutional courts. Of course, we have direct contacts. The members of these institutions organize joint study tours, study visits, seminars, workshops, etc. Then nowadays, more and more often, national constitutional courts are referring to EU law and referring to the case law of the Court of Justice. This cross-reference can be considered another contact between the 2 sides. And of course, we have the preliminary ruling procedure, which from my perspective is the most important tool used in the judicial dialogue. Due to lack of time, I won't speak about other perspectives. For example, we have to mention that judicial deference also plays a salient role in this relationship. And we have to mention that there are dissenting opinions, let's say that. Some scholars consider that we cannot talk about true judicial dialogue, rather about parallel monologues nowadays. But instead of these views, I would like to say a few words about the general relationship between the Court of Justice and the Constitutional Court of Romania. At the outset, one has to mention that the Constitutional Court's approach towards EU law is fluctuating and cautious at the same time, according to the Romanian commentators. According to Károly Benke, who is currently serving as the first magistrate assistant of the Constitutional Court, one can differentiate between 5 periods in this relationship. The first period was between 2003 and 2006, so prior to Romania's accession to the EU. It's interesting that during these years, the Constitutional Court has already referred to the case law of the Court of Justice. It cited numerous times the Mongol decision. The second period was between 2007 and 2008. This can be characterized by amateur and contradictory judgments. Then the longest period was between 2009 and 2018. During these years, the Constitutional Court consolidated its case law, it cleared up its approach, and it became more engaged to a loyal dialogue. That's why the 4th period is quite interesting, which was between 2018 and 2022. During this period, some judicial tensions arose, which actually led to a failed dialogue concerning the issue of the organization of the Romanian judiciary. Currently, we are in the 5th period, which has started in 2022, and it is marked by a turn to a lenient approach towards the Court of Justice of the EU. In this relationship between the Constitutional Court and the Court of Justice, I think that the approach of both sides have some shortcomings. For example, the case law of the Constitutional Court is fluctuating between an often innovative servile Europeanism, as the literature says, and a strong sovereignist position, whilst the Court of Justice of the European Union, in the before-mentioned cases related to the organization of the judiciary in the beginning of the 2020s, issued overly simplistic judgments in which it tried to apply by analogy the case law created or developed in relation to Poland to the Romanian situation, but without taking into account the specificities of the Romanian judiciary and the organization of the Romanian judiciary. For example, we had a specific cooperation and verification mechanism since 2007, since the accession, and we have changed our judiciary and our judicial system based on this cooperation and verification mechanism numerous times, and it was not taken into account. These aspects were not taken into account by the Court of Justice. It just reflected the cooperation and verification mechanism. Now let's turn to the exact tools used in judicial dialogue, and first I would like to mention the preliminary ruling procedure, which, as I mentioned earlier, according to me, is the only direct tool in the dialogue. Here, once again, we have to differentiate between three different periods. During the first years after the accession, so between 2007 and 2011, the Constitutional Court of Romania refused to refer any question to the Court of Justice without giving any explanation. The turning point came in 2011, when by decision 668 of 2011, the Constitutional Court created the theoretical framework for reference. However, the first concrete case appeared only in 2018. In the given case, the Constitutional Court asked the Court of Justice of the EU to clarify what the term spouse means in EU law. And interestingly, after receiving the Court of Justice judgment, the Constitutional Court found that the contested provisions of the Romanian Civil Code are constitutional only, and I will cite the court, if they permit the granting of the right to reside in the territory of the Romanian state under the conditions provided by EU law to spouses of same-sex marriages concluded or contracted in a member state of the European Union. It's the famous Hamilton-Coman case, and the related Hamilton-Coman judgment of the Court of Justice and Hamilton-Coman decision of the Constitutional Court. Unfortunately, until today, this is the only case in which the Constitutional Court referred to the Court of Justice, although generally I believe that using this tool more often would be beneficial. On the one hand, it would give more power to the Constitutional Court, it would give more weight to it in this whole judicial dialogue, and on the other hand, it would be an optimal solution to bring national provisions into line with EU law norms. The second tool used in judicial dialogue is represented by the Constitutional Court's reference to the case law of the Court of Justice of the EU. According to some Romanian scholars, this reference can be seen only as an alternative or hidden dialogue. Nonetheless, we have to highlight, as I mentioned already before, that the Constitutional Court used the case law of the Court of Justice already before Romania's accession to the EU. And as you can see on this table, on this slide, in the past 5 years, reference to CJEU's judgments appeared in more than 200 decisions of the Constitutional Court. Moreover, since the before-mentioned decision 668 of 2011, the Constitutional Court can use EU law as a rule interposed to the reference one. So basically, if two main requirements are fulfilled, the Constitutional Court can review the constitutionality of a domestic law provision through the lens of its conformity with the given EU law norm. These two requirements are the following. First, the EU law has to be clear, precise, and unequivocal, or has to be clearly, precise, and unequivocally determined, clarified by the Court of Justice. And the EU law has to be constitutionally relevant to a certain extent. both requirements are relatively rarely fulfilled. As you can see at this chart, in the past 5 years, both requirements were fulfilled only in one case. In the other cases, at least one of them was not fulfilled. For example, in 11 cases, the second requirement was not met, so the Constitutional Court considered that the given EU law provision is not relevant constitutionally. The third tool is an indirect tool. It's represented by those seminars, conferences at which both the members of the Court of Justice and the members of national constitutional courts are present. And I would like to highlight here 2 Romanian examples. First conference was organized in 2019 by the Constitutional Court of Romania. It was entitled National Constitutional Identity in the Context of European Law. And interestingly, after the conference, a book under the same title was published by the prestigious Romanian publishing house Hamanju. You can find this book online as well. The second conference was organized in 2022 by the National Institute of Magistracy. It was entitled Evolution of the European Union Law, Dialogue between the Court of Justice of the European Union and the Constitutional Courts. Interestingly, at this conference, both the president of the Court of Justice and the president of the Constitutional Court of Romania were present. So the direct dialogue appeared at this conference. And last but not least, again, a rather indirect tool is represented by the Constitutional Court's reaction to given judgments of the Court of Justice. And here I would like to highlight one specific example. Just before Christmas Eve in 2021, the Constitutional Court issued a press release as a reaction to the famous Eurobox promotion judgment of the Court of Justice. In this press release, the Constitutional Court highlighted that the given judgment of the Court of Justice can only be applied in Romania after amending the Constitution. Although this press release is not legally binding, the arguments put forward in it might appear in the future case law of the Constitutional Court. This press release is also important because it basically ended up this whole judicial tension period between the two institutions, and it is a representation of the failed dialogue. And instead of conclusions, I would like to draw a map of this whole network of tools used in judicial dialogue. As you can see, there is a direct link between the two institutions, represented by the preliminary ruling procedure. There are indirect links, conferences, seminars, etc. There is a direct link between the case law of the two institutions, so between the decisions of the Constitutional Courts and the judgments of the Court of Justice. It's represented by cross-reference. And of course, we had that press release, which is a mark of a failed dialogue, as you can see on this map. Thank you very much for your attention. And if you have any questions, feel free.